Hi, everybody. Welcome to the Patti Brennan Show. Whether you have $20 or $20 million, especially today, this show is for those of you who want to protect, grow, and use your assets to live your very best lives. Why today? Well, today we're going to be talking about the default estate plan and why you don't want it. According to a 2025 study, 76% of Americans don't even have a will. So if you're one of those 76%, you might think you don't have an estate plan. Well, I'm here to tell you the state has one for you, and it may not be what you want. Basically, what we're going to do today is going to walk you through what the default plan is, and then I'm going to have you go to our website, download our checklist called Beyond the Will, and I'll walk you through it, just to make sure that that doesn't happen to you. This stuff doesn't have to be difficult. Sure, you have to do something about it, right? That's all. And I'm here to nudge you along. So, number one, why is the default estate plan terrible? Well, for example, in Pennsylvania, if you have children and you're married, your spouse will receive $30,000 and 50% of the remainder. Is that going to be enough? You really got to understand what not having a will can do to you and your financial security. It's hard enough when children lose one parent. It's even harder when they lose the second parent because they have to work 3 jobs just to make ends meet. So let's make sure that that doesn't happen. So also with the default estate plan, the state, Pennsylvania in our case, has no idea the family dynamics. They have no idea that you're estranged from your siblings, that you've got a child with special needs. The state doesn't care. It's just got its formula and it's going to apply it. We've already talked about every state has its laws of intestacy. Just look it up and figure it out. It's easier to get a will and lay it out. Basically, all it is a letter to the executor to say, here's what I want to have happen. If I'm not here, here's who I would like to take care of our children. Because it's hard enough for kids. The anxiety level is off the charts. You don't want them to have to trudge through an orphan's court proceeding to figure out who they're going to be living with. That's really painful. And by the way, the person that the judge chooses may not be the person that you would choose. They may have different values. And the infighting that tends to occur is off the charts because grandparents think that they are best suited, whereas siblings might think that they're better suited, etc. You get to decide who's going to raise your children. In addition to that, you need a healthcare power of attorney. And by the way, so do your kids. Many of you have already heard my story of what happened with our son when he had a traumatic brain injury. I have to tell you that by the grace of God, he was 17 years old and 9 months, because if he was 18 years old when I called the hospital, because we were out of town, of course, I would have been just some crazy lady on the phone. They would not have been able, because of HIPAA, to give me any information or even acknowledge that he was in the ER on a ventilator. Nothing. So here's the thing. When your children turn the age of 18, get them a healthcare power of attorney. A will probably isn't as important for your children, but the healthcare power of attorney is. Don't wait until they graduate from college. Don't wait until they get married. When they turn 18, get a healthcare power of attorney for that child. And by the way, you need one too. Who's going to make those decisions? And we can talk a little bit more about how you want to be cared for and something called the 5 wishes that I'm really passionate about. But that's really important. Also, included in that process is the financial power of attorney. By the way, who's going to pay your bills if you're in a car accident and you're not dead, right? So the will only applies if you're dead, right? So you're in a coma. You don't want your credit rating to go to 500 just because you weren't able to pay your bills. Also, without a power of attorney, your spouse, for example, can't do a darn thing on any of your retirement accounts. There is no institution in America that will talk to anybody but you, and you can't talk because you've been in a car accident. So don't let that happen, and don't let your financial assets to be held in limbo or frozen, worse than that. They could be frozen if you don't have proper oversight. Last but not least, double check your beneficiary designations. I can't tell you how many times we talk with people who may be divorced and their ex-spouse is still listed as the beneficiary. That is unbelievable, but it happens a lot more than you realize. Also, with life insurance, we've had situations where people named a trust, and when the tax laws changed, they got rid of the trust, but they forgot to change the beneficiary designation. We had one estate that was tied up for years because the insurance company refused to pay out the death benefit. And that was really hard for the surviving spouse. So let's talk about what your plan should look like. Pull out your estate planning checklist. It's really simple. Remember, a will is just a letter to the executor telling them what you would like to have happen. Always keep in mind that your will only controls those assets that don't already have a beneficiary designation. So your retirement accounts, your life insurance, that goes outside of your estate. There's no probate. Depending on the state in which you live and the cost of probate, that may or may not be a desirable outcome. If you don't want anyone to have to go through the probate process at all, you can set up something called a revocable trust. Basically, it's a will substitute. Everything that you would put in a will, you basically put in the name of the revocable trust. It's in your Social Security number, so it's as if you owned it outright. The advantage is, upon your death, it's already outlined exactly what would happen, so you don't have to go to the courthouse, or your executor doesn't have to go to the courthouse to get the blessing to go ahead and distribute the assets. It's pretty much already been laid out. So a revocable trust can be advantageous depending on where you live, the state, the county, etc. One really important thing, a revocable trust does not provide any asset protection and it doesn't save any taxes whatsoever. So do it to avoid probate, that's fine, but that's pretty much all it's going to accomplish. You can also have an advance directive, a living will, that specifies exactly what you would want to have happen and what you don't want to have happen. A durable power of attorney is instantly effective. A springing power of attorney is different. In other words, the person who you've named has to prove that you're not able to act on your own behalf. The ones that we've reviewed requires a physician to sign off on it. That may or may not be what you want. It does tend to slow things down. When it comes to your beneficiary designations, always remember your beneficiary designation supersedes your will. So, for example, I could say that I would like my 401k to go to my 4 children in my will, but if I've named Ed as my beneficiary, that's it. Ed gets it all. The kids don't get it at all if I died first. So the beneficiary designations on everything supersede your will. Also, keep in mind that you can even name a bank account or a brokerage account with a beneficiary. A bank account is called a POD, a payable on death account. A brokerage account would be a TOD, a transfer on death account. So basically, you've got to be really careful about those designations, though, because you do want something left in the estate to pay bills, funeral expenses, etc. If everything goes by way of beneficiary, there's nothing in the estate to take care of inheritance taxes, things of that nature. So you got to really be careful about how you set things up. I do understand that you want to make things as easy as possible for the people that you're leaving behind. Just be conscious of the unintended consequences. There are other things that you can do in your estate planning. You can set up a crummy provision, crummy trust. That's often done with life insurance. You can set up a spousal lifetime access trust. These are tax savings ideas, qualified personal residence trust, or a family limited partnership. We get involved in these estate planning, these advanced planning techniques. They can be incredibly effective, but just be careful. You don't want overkill. You don't want to get things overly complicated. We have a new estate tax law that has really changed the dynamic and changed the framework upon which we make these decisions. Also, keep in mind, gifting is one of the easiest things that you can do. In Pennsylvania, the biggest benefit is it avoids an inheritance tax because while your surviving spouse doesn't have to pay a tax, your children do. In Pennsylvania, that tax is 12%. Non-relatives have to pay a 15% tax in Pennsylvania. So if you have a friend or if there's a child that you want to take care of and bequeath money to, why don't you do it with warm hands? Because that'll save them 15% tax. Siblings also have to pay an inheritance tax of 12%. So again, depending on where you live, taxes are still a consideration. Gifting is a great way to get around that. But be careful, because you don't want to look back and say, I wish I hadn't done that. I could really use that money now. Once you make a gift, it's an irrevocable decision. It's a done deal. So you got to be really careful about that. And that, by the way, includes gifting to charities. I think one of the most effective ways to save money is to name a charity as a beneficiary on your IRA, because charities don't pay income taxes on it. So if you want to recognize causes that you believe in, you can do it that way. Much cleaner, much easier, and much more tax efficient. We have a new tax law that has to do with inherited IRAs. Many of you have already heard our podcast on how that works. But whoever you leave those IRAs to and those retirement plans, they have to take it out of that shelter within 10 years period of time. A charity, on the other hand, doesn't. And by the way, they don't have to pay taxes when they take it out. So keep that in mind when you're thinking about your planning. You've got different buckets in different locations. Hopefully they're all in one place so you can keep track and they can keep track. But these buckets could be pre-tax, they could be after-tax. There's lots of considerations when it comes to doing this planning. We don't want to overcomplicate things with advanced techniques, etc., but there are definitely some perks that you want to be aware of. That's why the default estate plan is the pits. It just doesn't work because it doesn't understand you, it doesn't understand how hard you've worked, and it doesn't know what you want to have happen. It's just going to follow the formula. So take a few minutes, go online, write down what you would want to have happen. Depending on the state in which you live, holographic wills are legally enforceable. You can handwrite a will, have it notarized, have it witnessed by two people. Guess what? That is legally enforceable. You don't have to get fancy, just figure it out. Thank you so much for tuning in. I hope this was helpful. I hope you have a wonderful day, and I hope you take just the first step. All I ask is one step. Do one thing. Make a phone call. Talk to your spouse. What do we want to have happen? And get it done. Don't go by default. It's not going to be pretty. Thanks a lot for tuning in. I'm Patti Brennan, CEO of Key Financial. Go to our website, www.keyfinancialinc.com. There's a ton of checklists on the website. People tell us these checklists have been so helpful to them, and I hope it's helpful to you. Take care now. Bye-bye.
The following presentation is sponsored by Key Financial Incorporated. The Patti Brennan Show is intended for general information purposes. Only any non-employee guest speaker who joins Patti Brennan on the show is a guest and is not an affiliate of Key Financial. Their remarks do not necessarily reflect Key Financial's opinions or positions. Key Financial neither prepared nor verified any portion of our non-employee guests' presentation content and has relied upon the accuracy thereof. No portion of the presentation serves as the receipt of or a substitute for personalized investment advice from Key Financial or from any other investment professional of your choosing. Neither the information or opinions contained in this or any podcast, white paper, or on Key Financial Inc.'s website constitutes a solicitation for the purchase or sale of any securities and should not be relied upon as financial, legal, or tax advice. Content may be outdated, and past history is no guarantee of future results or experience. Please seek appropriate counsel from qualified professionals who know and understand your goals, objectives, and potential vulnerabilities. Thanks for listening to The Patti Brennan Show, brought to you by Key Financial Inc., wealth management with wisdom and care. Securities offered through Osaic Wealth, Incorporated, member FINRA SIPC. Investment advisory services offered through Key Financial Incorporated. Osaic Wealth is separately owned, and other entities and/or marketing names, products, or services referenced here are independent of Osaic Wealth.